A very good morning to our esteemed guest, Honorable Justice Katju, our Director Sir, Major General Nilendra Kumar, our faculty colleagues, and all our students. I would now call upon our Director Sir to kindly introduce our guest.
Justice Markandey Katju, the senior officials from the university present here, heads of institutions, faculty members, my dear students, ladies and gentlemen. I have immense pleasure in welcoming Justice Markandey Katju, a former judge of the Supreme Court of India, a former chairman of the Press Council of India. I was just going through the book of Fali Nariman before memory fades, and Nariman has said that he can roughly classify judges, eminent judges, in three categories: those with a political agenda, then those with a social agenda, and the third without an agenda. Justice Katju, a very tall judge. I'm not talking merely about his height, but the stature, and he was known all along, more than 2 decades that he adorned a seat at the higher judiciary as an intellectual judge. It's a red letter day for us here in the university that he accepted our request, in fact, Founder President's request to come and speak here today. I'll very briefly introduce his background and about him. He comes from a very distinguished family of Allahabad. His grandfather, Dr. K. Katju, was a defense minister and home minister at the Union in the cabinet of Pandit Nehru. He was also a chief minister. His father was also a judge of Allahabad High Court. His uncle was the Chief Justice. And Justice Markandey Katju had his education at Allahabad. All his career he stood first, completed his law, and started practice in 1967. He was a consul for various departments and ministries. And then he was elevated a judge in 1991. Continued to be a judge for 20 years. He was Chief Justice at Allahabad, then Madras, Delhi High Court, and finally he was elevated to the Supreme Court, where he was there for almost 6 years, and after retirement, as I said, he was the head of the Press Council of India. He is known to be a thinking judge. He has authored, edited 4 books, and it's amazing the wide spectrum that his books cover. One of the books is on taxation. The other deals with scientific temper as it concerns and impacts law. Yet the other book is on interpretation of statutes. And he did extensive research to bring in a book with his commentary and judgments when he later translated those principles into his judgments on the Mimamsa rule of interpretation. Now the senior law students who studied interpretation of statutes would recall that interpretation as taught today is mostly based on Western jurists. And here was a judge who went into the Vedic philosophy and India's heritage, juristic heritage, if I may say, to say and bring out that we had the notions of interpretation that are equally applicable today in cases where the Western juristic principles fail to interpret. Today, he has decided to speak on a topic that's of great interest, and it would interest not only law persons, the non-law audience present here today, that concerns the judiciary today, because the topic is judicial activism as well as judicial restraint. And in this, obviously, he will cover the judicial overreach. Now, there have been a number of important decisions by the Supreme Court that have brought to surface this issue relating to judicial activism, and wherein some of the judges have, if I can use the word, transgressed authority to deliver judgments that can be said appears to be judicial overreach. What he desired, the guest speaker today, that he would speak for about 50-55 minutes, and then he would be happy to take on any questions or comments. This is, as I said, a golden letter day, because we have a jurist of Justice Katju's eminence. With these words of introduction, may I invite you, sir, to please take the floor. Thank you.
Thank you, General Nilesh Kumar. I'm grateful to General Saab and others for having invited me here today. It is a pleasure to come to Amity, where I have come earlier also on some occasions. Today, I'm going to speak on judicial activism and judicial restraint. Have you people got your notebooks with you? Notebook and a pen? Please note down what I'm saying. See, this is a very sensitive and sometimes a very controversial subject. Before dealing with it, I would like to broadly tell you about 3 schools of jurisprudence. There are other schools also, but these are the 3 most important schools of jurisprudence, because first you have to get to know this, then you can understand the topic of judicial activism and judicial restraint. Broadly, these 3 schools are natural law, positivist jurisprudence, and sociological jurisprudence. There are other schools like historical jurisprudence and all, but I need not go into all that. The natural law theory says that along with the existing law, which may be either man-made, statutory law made by the legislature, or customary law, apart from the existing law, there is also a higher law which emanates from God or reason or morality and so on. And if there's a conflict between this higher law and the existing law, then the higher law will prevail. This is broadly the theory of natural law. Natural law theories existed in the time of the ancient Greeks and ancient Romans, but in modern times they arose at the time of the great revolutions, the American Revolution, the French Revolution, because when people were oppressed by the existing law, then they tried to conceive of some other law which could be of benefit to them, and they conceived of natural law as a higher law which will override the existing law if there's a conflict. Blackstone and Thomas Aquinas in the Middle Ages, they all said that if the existing law is in conflict with natural law, then the natural law will prevail. For example, in the American Declaration of Independence, it was said that we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, among which are life, liberty, and the pursuit of happiness. So it was believed that equality is something natural, liberty is something natural, which did not exist in the feudal age. These were initially proclaimed as slogans, but they later became statutory or constitutional rights. The problem with natural law, however, is that it is vague. What is natural? One person may regard one thing as natural, another person may regard some other thing as natural. The ancient Greeks and Romans regarded slavery as natural. In modern times, it is regarded unnatural, and equality is regarded natural. So you can't build up a legal system in modern times on the basis of vague concepts. Kelsen, the great positivist jurist of the 20th century, said that with natural law you can prove everything and nothing. And Bentham, another positivist jurist, said that natural law is metaphysical nonsense. After the natural law school came positivist jurisprudence. Now, positivist jurisprudence was the first attempt to create a scientific theory in jurisprudence. See, science examines and considers things as they are. For example, a physicist, he studies the atom, the electron, how they behave, not how they ought to behave. You examine things as they are, not how they ought to be. The natural law theory said that law is what it ought to be. Natural law theory said only a good law is law. But the positivist jurists made a clear distinction between law and morality. Positivist jurists, particularly Bentham and Austin of the 19th century, said that even a bad law is law, provided it emanates from the competent legislator. So you can't mix up law with morality and religion and so on. So this was a great advance over natural law, because natural law was something vague, and modern society requires clear-cut laws. If you have a factory, you have to have a clear-cut rules about the chain of command, the rights of workers and so on. We need precision, we need clarity, we need systematization. All this was sought to be introduced in positivist jurisprudence. The main positivist jurists of the 19th century were Bentham and Austin, as I mentioned. In the 20th century also, positivist jurisprudence has continued, and the main positivist jurist is Kelsen. Now, while positivist jurisprudence certainly made an advance over natural law by clearly demarcating law from morality, it had a great defect. And that was this, that the positivist jurists said that we should only study the structure of the law, the concepts of the law. We should not try to go into the question how this law came into existence, what was the historical background of this law, what were the social and economic factors which gave rise to the law. They said all that is outside the scope of jurisprudence. Thus, the positivist jurists reduced jurisprudence to a purely descriptive science of a low theoretical order. They very much narrowed down the scope of jurisprudence. If you read books by Salmon, Peyton, and so on, Hart, they discuss the structure of the law, the concepts in law like property, contract, etc. They don't go into the question about how this law came into existence, what were the historical factors which gave rise to the law, and so on. So they reduced jurisprudence to a very narrow scope, a purely descriptive science of a low theoretical order. This defect, and this was a defect because unless you know the historical background of the law, how it came into existence, why it came into existence, you will not be able to properly understand it. You must know the socio-economic background of the law. So this defect in positivist jurisprudence was sought to be removed by sociological jurisprudence, which began in Western Europe in the 19th century, but it was considerably spread in the United States of America. The sociological jurists treated law not in isolation, as the positivist jurists did, but as part of the social reality. And they said you have to go into the questions as to how this law came into existence, what were the historical and social and economic factors which gave rise to the law. All that is part of jurisprudence. It's not just part of sociology, as the positivist jurists said. So they considerably widened the scope of jurisprudence. There are many schools of sociological jurisprudence, like, for example, Ehrlich's Living Law School, then Jering's School of Reconciling Conflicting Social Interests, which was broadly copied by Roscoe Pound in the United States, etc. I need not go into all those schools. There are a large number of schools of sociological jurisprudence. But one main thing which the sociological jurists did was that they shifted the center of gravity of the legal system from statute to judge-made law. See, positivist jurists place great emphasis on statutory law, unlike, say, historical jurisprudence, which played great emphasis on customary law. As Austin said, that law is the command of the sovereign. Now, the sociological jurists, they played great emphasis on judge-made law. Roscoe Pound said that, see, a positivist jurist said that law is a set of rules which are enforced by the state. Whereas Roscoe Pound said that law is an instrument for reconciling social interests. It's not just a set of rules. In fact, the extreme school of sociological jurisprudence in the United States, known as the realist school of jurisprudence. The realist school of jurisprudence said that, in fact, statute is not law at all. It is just the raw material which a judge uses to make law. The realist jurists like Gray, Llewellyn, Frank, they said it is the judgment which the judge gives, particularly of the US Supreme Court, that is law, not what you find in the statutes made by the Congress and all. That's just the raw material which the judges are using. Now, I've given you a broad background of these three schools of jurisprudence. In some other lecture where I will deal with jurisprudence, I can come again and I will go into further detail. But for the time being, this is enough for this subject: judicial activism and judicial restraint. You see, we are broadly following the British legal principles because we were a colony of England, and so was the United States at one time. They followed British principles. In England, they had the principle of parliamentary supremacy. There was no written constitution, and Parliament was supreme. Even the courts were subordinate to Parliament. So there the principle was of judicial restraint. The principle of literal rule of interpretation was very strictly followed, because if the judge can twist the law, twist the statute made by Parliament, then in fact he is violating the principle of parliamentary supremacy. Then the judge is himself assuming supremacy if he adds words to a statute or deletes words from a statute by his judgment. It is violation of the principle of parliamentary supremacy. So the British judges were very restrained, conservative, as it is said that a judge should be like a referee in a football match. He should neither play in the match, nor should he advise the players how to play. He should only blow the whistle if there's a foul or the ball goes outside the boundary line. Otherwise, he should not take part in the game at all. He should be reserved, he should hear the arguments of lawyers and then give judgment strictly according to the letter of the law and not deviate from it. This principle of literal interpretation was very strictly followed in England. You see, broadly, there are two principles of interpretation, broadly. First principle is the literal rule of interpretation, and the second is called intention seeking. The literal rule of interpretation is not only followed by lawyers and judges, it is followed by the common man on the street. Because the literal rule of interpretation merely means that we mean what we say and we say what we mean. If I say this is a bottle, I mean it is a bottle. And not that I say it is a bottle, but I mean it is a horse or a donkey or elephant or something. I mean what I say and I say what I mean. This is the literal rule of interpretation, which means you read the words as they are. Don't try to change them, don't try to twist them, don't try to add words, don't try to delete words from the plain words of the statute. Otherwise, if you don't follow the literal rule of interpretation, then communication between us will become impossible. If I say this is a bottle, but I mean it is a horse or a donkey, you and I will not be able to communicate with each other. Broadly, this is the literal rule of interpretation, and it was very strictly followed in England. Now, the departure came because in modern times, society has become dynamic as contrasted to feudal times when it was broadly stable. And because of new scientific inventions and discoveries, society changes. New subjects arise on which there is no legislation. There are gaps in the law where there is no statute. What is the judge to do in this situation if a case comes before him? The sociological jurists advocated an activist role of the judiciary, that in certain circumstances judges can make law. I may give you one or two illustrations. See, in modern times, the right of a woman to have sex without having pregnancy is a basic right. See, up to feudal times, every woman would have 15 to 20 children. There were no contraceptives. You got married at a very young age. Every year or so there was a child. Every woman, all your great-great-grandmothers had 15, 20 children. Of course, most of them died because medical science was not advanced, so hardly 4 or 5 of the children survived. You remember Mumtaz Mahal died giving birth to a 13th or 14th child. So every woman would have 15, 20 children. But today, in modern times, we can't afford more than 2 children or so, because on each child a lot of money and time has to be invested. It's very expensive. So everybody, all middle class people practice contraception. Most middle class people have 1 or 2 children. You can't afford to have more. And a woman, women are also working nowadays, they don't want to have too many children. So the right of a woman to have sex without having pregnancy is a basic right. In Ireland, I'm talking of the Irish Republic, not North Ireland. Irish Republic is a Catholic country. There was a law against the sale and use of contraceptives. Because you know, Catholics don't like contraception. They're conservative people. But the problem was, although this law was antiquated, outdated, archaic, totally unsuited to the modern age, no politician in Ireland, no member of parliament, had the courage to bring a bill in parliament to abolish this outdated law, out of fear that if he did, the Catholic Church would use its enormous influence to destroy the political career of that politician. So no one had the guts to bring such a bill. In 1970,